So hello, everybody. I'm Sean. I'm the program manager for MiDEAL, the state of Michigan's extended purchasing program, which I'm sure all of you know because you're all members of our program. And I'd like to welcome you to our MiDEAL training series. Today we are gathered by Gavin. That's great. Today we are joined by Gavin LaCombra, and I probably didn't say that right. LaCombra? There we go. The risk manager with Central Procurement Services. Just a little bit about our risk manager, Gavin. He's with the state of Michigan. He's responsible for all insurance-related matters involving state government operations. His day-to-day responsibilities generally involve administering the commercial and self-insurance policies for the state, which seems like a big lift, collaborating with the Attorney General's office in the litigation and settlement of automobile liability claims, and assisting the state agencies and department purchasing staff with developing and understanding insurance terms and contracts. Wow, that's a lot. Gavin, he earned his bachelor's degree in criminology from the Florida State University, a master's degree in public administration from Webster University. You're an overachiever. You know that, right? Okay. And a Juris Doctorate from the Thomas and Pooley Law School. So wonderful. We're thrilled to have you with us today. I'm gonna turn it over to you in just a second, but I'm gonna go through some housekeeping notes. Just checking our numbers. Okay, we got even more people in. Welcome. So we are recording the webinar and it will be added to the MiDEAL YouTube channel for future reference. Closed captioning has been enabled and you can turn on your version by clicking the CC button, which is either located at the bottom or top of your screen. And with such a great turnout, all phone lines are muted. However, you can submit a question by clicking the Q&A box, which is also located in that toolbar. If we aren't able to get to all of the questions, or maybe Gavin's not sure how to answer a specific question, we will put together a Q&A summary and get that out to you following the webinar, if necessary. We do encourage you to participate in the polling questions that we're going to ask during the webinar, and always completing that survey following the event, just so that we can make sure we continuously offer webinars and programs that fit your needs. So now I'd like to turn it over to Gavin. You know what? I've already failed on advancing the slides because
I don't want to interrupt
that one would have been a nice one to share. See, that's why, you know, I shouldn't be in charge of this, but that's okay. Okay, so let's get over here to the agenda overview. If you'd like to take over, I'll mute myself so that I don't interrupt you.
All right. So yeah, good morning, everybody. I'm happy to be here. As Sean has up on the screen, you'll see an overview of what we'll be discussing today. First, we're going to start out with a brief overview of the contractual risk process and how risk is assessed with any given purchase. We'll also go over a few basic insurance terms that are important to familiarize yourself with. We'll also talk about some standard contractual insurance requirements that the state of Michigan uses in their contracts. And we're going to also talk about non-standard insurance requirements that the state of Michigan uses when certain risks might implicate the need for insurance requirements outside of those standards. And then we'll also take a look at a certificate of insurance and review the various parts of what a certificate looks like. And then finally, we're going to bring it all together and review a sample contract, an actual past contract of the state of Michigan's, and the certificate of insurance that the contractor submitted, so that we can determine whether or not the contractor actually met the insurance requirements by looking at their certificate of insurance. So as an aside, before we go any further, just wanted to kind of put out there to start with that this presentation is a very high level discussion of what can be considered some pretty complicated insurance and risk management principles. But so in the interest of time, unfortunately, we won't be able to go down the many rabbit holes of the insurance industry during this training. But as Sean mentioned, if you do have any questions that we won't be able to get to or that might exceed the scope of this training, we'll try to address those and answer them in our follow-up communication.
But Gavin, rabbit holes are our favorite place to go. I'm just kidding.
They are. But I can talk for hours on end.
Yes. So, okay, I'll carry on. I'll let you continue.
Go ahead and go to the next slide. All right,
It's on the understanding the risk. Is that one the right one?
that's right. Yep.
Okay.
Yep. So, and before we go any further too, I just want to put out a couple of apologies in advance. Sean and I decided that it's probably best that she go through the slides. So you're probably going to hear me say next slide several times throughout this training. And I'm actually kind of suffering from a little bit of seasonal allergies, so I might have to reach for some liquid relief to make sure I don't lose my voice. So
We're a pretty easygoing group, so I think you're good. I will do my best to support you with advancing.
all right, thank you.
Yes.
Okay, so let's talk about the risk transfer process a little bit. So what risk transfer is actually, it's a risk management and control strategy that essentially shifts liability of any future risks from one party to another. And so from a purchasing or procurement perspective, it's a contractual agreement in which a contractor agrees to assume liability for any harm that they would cause while providing their products or services, whether it's bodily injury or property damage or otherwise. And why we transfer risk is to make sure that the state of Michigan or your entity is protected from that liability that arises out of a contractor's negligence. How we transfer risk is done in two different ways in our contracts. We have what's called an indemnification provision, where the contractor agrees to hold the state harmless for anything that's essentially their fault. And then we also have proper insurance requirements, which we require insurance because it actually holds the contractor to their promise that they will indemnify the state of Michigan. Go to the next slide. And so in order to properly assess the risk involved with any particular purchase, you really have to consider the who, what, where, when, and how. So for example, who could be harmed during the activity? The general public, government employees, residents nearby, children. What activities are being performed and what would the maximum loss be? Is the work dangerous? Would it affect a large or number of people or geographic area? Where are the activities taking place? Are they being taken, are the services being performed on site? Are they being performed on the vendor's property or the contractor's property? When are the activities taking place? Are they taking place during the evening or the nighttime? Are they taking a time during a sporting event? And then finally, how likely would your entity, or in our case, the state of Michigan, be named as a defendant in a lawsuit if there was a loss resulting from the activities being performed? Next slide brings us to our first poll question.
All right, back to me. Let's get this first poll question up. Okay, can you see that okay? I'm asking Gavin.
Yes, yes.
Nobody else can answer me. Okay, if you don't mind answering this, it's acceptable if a vendor's insurance does not meet specifications, true or false? Okay, let's give it a second. Oh, we got all kinds of participants. Exciting. All right, I'm going to end the poll here in just a second. And let's share the results. And then Gavin, do you want to answer this one and let us know?
Sure, yeah, the correct answer is false. It's not generally recommended to modify insurance requirements to fit a particular contractor's coverage. And the reason why is it's you really want to consider the loss exposure or the risk exposure, not necessarily the value of the contract, which is typically why a contractor wants to modify the insurance requirements or asks for the state of Michigan to have the insurance requirements fit their situation, because you never know if the contractor is underinsuring their risks. And for several reasons, maybe because they don't have experience performing services where the loss exposure is so high, like providing services to a governmental entity, or maybe because they're just not willing to take on the added cost of a higher premium. So yeah, it's not necessarily acceptable to fit the insurance requirements to a vendor's insurance situation.
We do have a question. Is it possible for us to share the slides after? Are you okay with that?
Yeah, absolutely.
Maybe take a look and see if there's any things we need to tweak, but yeah, we can work on that. Okay. Let's move on. Your disclaimer.
Yeah, again, before moving on, I should mention that you always, in any contract situation, you're always going to want to consult with your legal team or your risk management team before making any changes to insurance requirements or to the contract at all, because sometimes a purchasing or procurement, someone in the purchasing or procurement staff may not realize or consider that there is an important risk factor that could result in financial harm. So it's always good to get a second pair of eyes or consultation from your legal or risk team. So Sean, I'm not sure if everyone's seeing the same thing I'm seeing, but it looks like the poll question is still on the screen. I don't know if I have to close that out or.
No, it's a good question. Let's see here. Poll. I don't know. It's not showing up on my end.
I can click the X on my screen.
Click that and see if it goes away.
It went away for me.
Okay, very good. Hopefully it's gone away for everybody else. Yeah, it went away on my end too.
Okay, perfect.
Sure.
All right, so getting into some insurance basics. Some of the standard contract terms that the state of Michigan has in every contract are listed here on the screen on this slide. So first bullet point there is that we actually require that a contractor's insurance company have a minimum AM Best rating. And so for those of you who don't know, an AM Best rating is essentially like an insurance company's credit score. It provides insight to an insurance company's ability to pay insurance claims and then continue to meet its financial obligations as a business. The letter portion of the AM Best rating indicates an insurance company's financial strength. So it's, again, their ability to meet ongoing insurance obligations. And that usually ranges from an A+ at the highest to the lowest score, which is a D. The second portion of the AM Best rating is the Roman numeral, and that's the rating of the insurance company's financial size. So how much surplus they have. And that would range from class 1, Roman numeral 1, all the way to class 15. And we're right in the middle as far as the financial size. We require it to be a 7. The second bullet point there is we require a contractor's insurance be what's known as primary and non-contributory, meaning that the insurance policy will be the only policy paying on a particular claim, and that the carrier will not seek contribution from any other policy that covers the same risk. Again, high level, very complicated insurance term of art. So moving on to the next third point there, the state of Michigan requires that notification of any policy being canceled. We require notice in advance because obviously if a required policy is canceled, that essentially transfers the risk back to the state of Michigan. It kind of defeats the purpose of requiring an insurance policy to begin with. And then the last bullet point on there, a defined deductible maximum or self-insured retention. The state of Michigan actually doesn't require that as a standard anymore as of maybe the past couple of years, but it is something we can impose in a contract if there's any particular concern that a contractor doesn't have the sufficient financial backing. Next slide.
Gavin, do you have time for a question?
Sure.
Okay, question is, how do you check the AM Best rating?
So AM Best, if I recall correctly, the website ambest.com might be something as simple as that. You might want to Google it to be sure, but they have a website where you can actually type in the name of the insurance company or their NAICS number, which we'll kind of find out where you can, what the NAICS number is on the certificate of insurance. But when you type in the insurance company's name, they may or may not be rated by AM Best. Without going down that rabbit hole I was referring to earlier, there's an explanation of how an insurance company is rated, and if they're not rated by AM Best, why they're not rated by AM Best.
And you are correct. It is ambest.com. Keeping it simple. All right, let's move on to the next.
Okay, so some insurance definitions for a few terms of art in the insurance industry that you'll see come up a lot in contracts, and they're important to familiarize yourself with. The first one there, occurrence basis or occurrence-based coverage, is where a policy provides coverage for a loss that occurs during the policy period, regardless of when the claim is actually filed. And in contrast, the second bullet point there, a claims-made basis is a policy that provides coverage if the loss occurs during the policy period and the claim is filed during the policy period. So it's a little more strict. A claims-based policy is a little more strict. An additional insured, you'll hear me say additional insured several times throughout this presentation. What that is, it's a policy endorsement that adds another party, in our case, the state of Michigan, to the policy. So in other words, they're adding us as an additional insured. So we're now insured or a covered party under their policy. Another term that you'll hear me reference quite a few times throughout this presentation is waiver of subrogation. And that's a policy endorsement where the insurance company is essentially giving up or waiving its right to subrogate. So in other words, they're not going to try to recover money that they paid out from the third party who may also have been negligent in causing the injury or damage. And we'll discuss this in a few minutes, but we require a waiver of subrogation for workers' compensation. The last bullet point there is loss payee. And that's an endorsement that entitles a third party, so the state of Michigan, to all or part of the insurance proceeds in connection to a claim in which that third party, state of Michigan, has a direct interest. Now, this differs, it's similar, but it differs from an additional insured endorsement in that a loss payee has a property interest, whereas an additional insured has a liability interest. And we'll go through a couple examples in some of the slides up ahead, but just wanted to give you a difference between additional insured and loss payee. We can go to the next slide. So in the state of Michigan Central Procurement Office, we have what we call a set of standard insurance requirements that are in most contracts. And those are listed here on the slide: commercial general liability, auto liability, workers' compensation, and employer's liability. And the next few slides are going to go into these a little bit more in detail. So we'll go on to the next slide. So general liability provides coverage for bodily injury and property damage. The state of Michigan also requires additional sublimits of coverage for personal and advertising injury. So things that for like defamation and copyright infringement. And then another sublimit for products and completed operations. And that covers liability for injury or property damage associated with defective products or completed services. And then the state requires that it be listed as an additional insured on the contractor's general liability policy. Next slide shows, here's a sample of our commercial general liability requirement in contracts. And what you see on your screen here is actually what a buyer in our office would see before the solicitation actually gets put out there. Like that green where it says read and delete, that actually signals the buyer who's administering the contract to read that language and then delete it, depending on whether or not the language right below it would apply. So for example, it says that language below regarding exclusions about sexual abuse and molestation would be needed only if the contractor is dealing with children, schools, or the cognitively impaired. So that signals the buyer to read that language. And if that language below it does or doesn't apply, you would also either keep or remove that language. So just kind of give you an idea, we don't have those in our contracts. We don't have read and delete language in our contracts. But yeah, you'll see the specific minimum limits that we require on the left, and on the right-hand side, there's the requirement to add the state of Michigan as an additional insured. And then again, even though you see a deductible maximum, again, we no longer require that as a standard. But we do have the option to use it as a tool if there's any uncertainty about the contractor's financial ability. We'll go to the next slide. Polling question number 2.
All right, let's get that one up. Okay, hopefully that shows up on your end. Does a vendor need proof of automobile liability when hired to work on the premise? Yes, in every case. Yes, in most cases, or no, not needed. You all take a second to answer that for us. I'm very impressed with the participation. Those are coming in. All right, I'm going to end the poll here in just a sec. Okay, I'm going to share those results if you don't want to take the answering for us.
Sure thing. And I actually kind of like how there was a split almost down the middle between yes in every case and yes in most cases. As an attorney and risk manager, my answer would be yes in every case. However, the correct answer is yes in most cases. And we'll go into a little bit of detail in the next slide as to why. But yeah, the answer here is yes in most cases. We can go into the next. So let me close out my polling question on my screen. Go to the next slide. So yeah, as you know, in the state of Michigan, every vehicle owner is required to have auto liability coverage. And so it's important to require that contracts carry auto liability coverage, because if an injury or property damage arises out of the use of a motor vehicle, an auto liability policy is the only insurance policy that will cover the loss, because a general liability policy will not pay for a claim that results from a vehicle causing injury or property damage. So even in circumstances where vehicle use is minimal, driving into a parking lot and parking their vehicle, there's a risk of vehicular-based bodily injury or property damage. So going back to the polling question, I guess technically there's 2 right answers. In every circumstance, we really should be requiring auto liability coverage when services are being performed on site, because again, even the minimal use of driving a vehicle into a parking lot creates the risk of vehicular-based bodily injury and property damage, in which only an auto liability policy would pay out a claim. Having said that, you really kind of have to weigh, or the state, and at least from our point of view, we really have to weigh the risk versus the reward in terms of, let's say, for example, we have a very small contractor who doesn't have a commercial auto liability policy. In some circumstances, we would accept a personal auto liability policy, but that also kind of, again, not to go down that rabbit hole, that also kind of puts us in a precarious situation, because there are times where a personal auto insurance company will not pay for a claim where the contractor is actually considered, or may be considered acting in a business capacity. So if the work was being performed for business purposes, and a personal auto liability policy may not respond. But a lot of our contractors, like especially with Department of Health and Human Services, are sole proprietors or individuals who own a business and they don't have a commercial auto liability policy, and it would be cost prohibitive for them to obtain one. So every now and then we can get flexible with whether or not we'll just accept the fact that they have an auto liability policy because they're required to have one in the state of Michigan. Plus, going back to our very first slide, there's that indemnification or hold harmless provision in every contract. So really at the end of the day, they have to hold the state of Michigan harmless financially for any damage or injury they cause. So yeah, there's a lot of gray area, but in most circumstances, you want to require auto liability coverage whenever work is being performed on site. Sorry, Sean. The last two bullets there. The state requires this, that the contractor list the state as an additional insured on their policy, and we also require what's called hired and non-owned coverage. And very briefly, what hired coverage is where a contractor's vehicles are either rented or leased or borrowed for business purposes. And then non-owned are vehicles that the contractor doesn't own, lease, or borrow for business purposes. So for example, like employees' personal vehicles, a hired and non-owned coverage component to an auto liability policy would cover the contractor in those circumstances where they have hired and non-owned vehicles used for business purposes. All right, now we can go to the next slide.
Sorry, I got a little punch happy on that one. I do have a question that came in if you want me to read that one to you. What if the place where vehicles are being parked is space owned by the public or government? Is it okay for them to park in the lot as a customer? However, if they are doing business, they need more insurance to park in the lot. Hey, did that make sense to you?
I think it sounds like it was maybe a two-pronged question, whether or not it's acceptable, or whether they need insurance for parking in a publicly owned space, like a state or county or municipal parking lot where the public can park. And then whether or not that by doing so, they would need either proof of insurance or some kind of additional commercial policy insurance. And if that's the way that question is going, yeah, even when the parking space is publicly owned or the general public can park there, the risk of injury or property damage can still occur. And so because this contractor is providing service for the state of Michigan. So for example, the parking lot out in front of one of our government buildings, if they come on site and they go into the parking lot and end up hitting somebody on accident or hitting another vehicle for that matter, or even property or structure and causing property damage, because there's a contract between the state of Michigan and the contractor, we have those two protections in place. So the indemnification provision requires them to hold us harmless financially. And then the insurance requirement is a way to make sure that they have the financial backing to come to follow through on that indemnification provision. So I think if I answered the question in short answer, yes, they should still have insurance coverage, auto liability insurance coverage. And because they're required to have it anyway, it's always helpful to have proof of it in case any kind of injury or damage occurs. So on the slide now is an example of our auto liability insurance requirement that is in our contracts. We require $1 million per occurrence limit. And then over to the right is that language where we require the state to be listed as an additional insured, and that the policy include hired and non-owned coverage. The next type of standard coverage in state contracts is workers' compensation. And everyone's probably familiar with this type of insurance just by virtue of being employed. But for risk transfer purposes, we want to make sure that the contractor assumes liability for any of its employees on the job injuries. And with a few exceptions, all employers are required to carry workers' compensation coverage. And as I mentioned earlier, for workers' compensation, we require what's called a waiver of subrogation, unless it's prohibited by law. And again, a waiver of subrogation is a policy endorsement where the insurance company is giving up their right to recover any money against the state of Michigan if arguably we exercise some kind of negligence in causing the injury. At the bottom of the slide, there's an example of our workers' compensation requirement that's in our contracts, and you'll see that there's not a specific limit of coverage required. Instead, what we have is a sentence there that says coverage according to applicable laws governing work activities. And that's because in Michigan, the Department of Licensing and Regulatory Affairs is actually the governing entity with regard to the state's workers' compensation laws. And so depending on the type of work being performed, there may be federal requirements. So because workers' compensation is regulated differently in each state, and sometimes we have contractors that are based in another state, we put the onus on the contractor to follow the laws and regulations of their state and to know what types and limits of coverage is required.
I have a question for you.
Sure.
Does the state require proof by a vendor that they are exempt for workers' comp coverage? And if so, how?
Yes. Well, we don't necessarily require proof. We do ask that we do determine whether or not they are exempt from workers' compensation by either, they're a sole proprietor or they fit into one of those categories of employers that would be exempt. And so, again, because it's legally required for most employers, we essentially would take their word for it, because if they really weren't in compliance with the law, I mean, the lawsuit would ultimately fall back on them anyway. So if they don't provide on their certificate, and we'll get into this a little bit later, but if on their certificate of insurance they don't have a way, or they don't have proof of workers' compensation, we'll communicate with them and determine, is it because you're exempt from the workers' compensation requirement, or is it, did you forget to put it on your certificate of insurance? One way or another, we get clarity. And if they are exempt, we just waive that as a requirement. Again, understanding that if there was an on-the-job injury from by one of their employees, it would ultimately fall back on them anyway. So in the state of Michigan, just to kind of follow up on that a little bit, in the state of Michigan, they should get a form or some kind of documentation from LARA, the Licensing and Regulatory Affairs, saying that they are exempt from the requirement to carry workers' compensation. And so, yeah, this is an example, at the bottom there was an example of our workers' compensation requirement. And this, the next type of standard insurance requirement is kind of part and parcel of workers' compensation. It's what's known as employer's liability. And in Michigan, this type of coverage is provided as part of a workers' compensation policy. You can't have one without the other. So the workers' compensation portion of the coverage actually covers the on-the-job injury itself, whereas the employer's liability portion covers any claims for lawsuits that result from the on-the-job injury. So it's kind of like a Part A and Part B coverage. And it's important to note here that employer's liability coverage is different from employment practices liability, because what employment practices liability covers is things like employment-related claims. So wrongful termination, discrimination, harassment, things like that. Go to the next slide. Brings us to our third polling question.
All right, back with questions. So we've got our next polling question, and it says some contracts require more than standard insurance. True or false? Yes, great. A time for you to take a sip of water.
A little parched there.
You're going to be exhausted at the end of this. Okay, just a few more. Okay, and I'll share the results. So we've got the majority of them said true.
Yeah, good job, everybody. There are circumstances where more or different types of insurance coverage and higher limits may be required in addition to what we just went over, the standard insurance requirements. And the next few slides are actually going to discuss that. So depending on the risk exposure associated with the products or services being purchased, there may be a need to require insurance above and beyond those standard requirements that we just went over. Again, it's all about transferring the risk. Some examples here on this slide are seen, but there may even be other or additional insurance requirements outside of these that might be implicated, again, depending on the risk exposure. And each one of these that you see on your slide here, we're just going to briefly touch on over the next few slides here. Oh, and before that, though, we got to do our fourth polling question.
Sorry, it's fun trying to get all the right buttons clicked. Okay, let's get to poll number 4. When is umbrella or excess liability coverage necessary? A, when there's a high risk of a large loss due to, why isn't that question fully showing? There we go. Personal injury or property damage. B, when there's a low risk of loss due to personal injury or property damage. Or C, when it's raining. Gotta have a little fun.
Clever answer to C.
Yeah, come on. Okay. Everybody popped in quick on that one.
Yep, yeah, so the answer is A, when there's a risk of a large loss due to personal injury or property damage.
Okay, so not when it's raining. Got it.
It's raining, no, you don't.
Okay, carry on.
Expensive coverage to have every time it rains.
I know. Especially 2 days ago when I got soaked going into the office. All right, next slide.
Yeah, on that topic, umbrella liability insurance is basically an extension of a general liability policy limit. So in other words, it kicks in when the general liability policy limit has been reached. And so that's why it should be required when there's a high risk exposure, because maybe a contractor's general liability policy limit may not be enough to cover the risk involved. Now, sometimes an umbrella policy will also cover auto liability and workers' compensation, but generally it's just an extension of general liability policy. And so the state of Michigan requires, just like with general liability, that it be added as an additional insured to the contractor's policy. Next polling code. Looks like we're not giving you any break with these polling questions.
All right, keeping me on my toes. So polling question number 5. What type of vendor work need professional liability coverage? From the answers listed below: accounting, auditors, janitors, office supply distributors, A and B, or all of the above. These questions always trip me up in college.
Yeah, there's A and B and all.
Oh yeah, I'd be going back and forth between option D and E.
Yeah.
But then is it a trick? So yeah. All right, looks like we've got our typical participation rate, which is high. Thank you so much. I will end the poll and share the results.
So yeah, the answer here, looks like most of you answered correctly, is E. So of the choices listed here, professional liability should be required for accounting services and auditors.
I think that's D.
Or D, I'm sorry. D, the answer is A and B.
Yeah, got it. Okay. Fantastic.
All right, so yeah, talking about professional liability coverage. For contractors, professional liability, also called errors and omissions insurance, is intended to protect against lawsuits that allege negligence, misrepresentation, or inaccurate advice that's given during the provision of professional services. It's essentially like a malpractice insurance for professionals who aren't in the medical or the legal field, where I know a doctor would have medical malpractice or an attorney would have legal malpractice. Professional liability really achieves the same thing. The key here, though, is determining whether the services are professional to the extent that an error or omission in judgment could result in financial harm to the client receiving the services. So in our circumstance would be the state of Michigan or your entity. An easy way to determine that is to kind of think of it of whether the services involve brain work or physical work. So a couple of examples, like an accountant who makes a clerical or mathematical error that would cost their client thousands of dollars, or a real estate firm who sold a building knowing that the buyer intended to open a pet grooming business. And it turned out that pet grooming services are prohibited by the zoning laws. Or a construction firm who used what might be known in the construction industry as poor quality materials when constructing a building that might later collapse, and several lawsuits against the building's owner are filed. And then there's an example at the bottom of the screen there with our professional liability requirement. Again, we no longer require deductible maximum as a standard. All right, and the next type of non-standard insurance is privacy and security, or what's also called cyber liability insurance. And that's for claims involving data breaches where personal or sensitive information is at risk. And it should be required anytime a contractor has access to sensitive information, or what's called PII, personal identifiable information. And it's important to note that this type of policy covers both physical and electronic data. So not only data that's electronically stored and transferred, but physical documents and papers or files. With regard to being named as an additional insured on a cyber policy, we've actually, within the last year or so, found out that more and more carriers are no longer allowing another party to be named as an additional insured. So we don't require that as a standard practice for cyber liability, because what they'd essentially be doing is adding the entire state of Michigan to their insurance policy, which obviously could be cost prohibitive. And then the next slide shows an example of our cyber liability requirement. The limits to the left, and then the type of coverage that has to be part of the policy.
I have a question that came in.
Sure.
What insurance lines can a vendor not add the client as an additional insured?
That really varies from insurance company to insurance company. Generally, a third party cannot be added as an additional insured on any types of claims made policy. And we briefly touched on what a claims made policy is, but yeah, generally, if it's an errors and omissions type of policy, an insurance company does not want any kind of additional insured status given to any third party. But for the most part, a general liability policy and auto liability policy are really the extent of what we require to be named as an additional insured. There's a couple of others, but mostly general liability and auto liability is where it really applies. There shouldn't be any trouble. So crime or fidelity coverage is a type of insurance policy that protects a contractor against claims for theft or employee dishonesty. And this type of coverage is usually required when the contractor has access to or control over funds, whether it's cash, checks, banking information, things like that. And then we actually require that the state be named as a loss payee on the contractor's crime policy. And if you recall that a loss payee endorsement differs from an additional insured endorsement, in that the loss payee's interest is in property, whereas additional insured's interest is in liability. So in this circumstance, the state of Michigan's property interest is in the funds or the money that's at risk. Next slide is talking about environmental or pollution liability. And that covers risks associated with the contractor's job site operations. So if their services involve utilizing or disposing of hazardous material, this type of coverage should be required. And this is another one of those cases where we would require the state be named as an additional insured because of the liability interest the state has. The bottom of the screen there is an example of our insurance requirement. And note that to the right of the minimum limits, we have specific language pertaining to coverage exclusions or limitations. Now, as we briefly touched on earlier while discussing professional liability, medical malpractice is another type of non-standard type of insurance we might require when it's implicated. And this is basically professional liability for doctors and medical professionals. And it should be required when a contractor provides services such as treating, diagnosing medical issues, prescribing medications, etc. In our example of our requirement, we have the option, depending on the size of the contractor, to impose a $200,000 per occurrence with a 600 aggregate minimum limit, or a 1 million per occurrence limit with a 3 million aggregate limit. And then lastly, property insurance provides coverage for damage to structures, buildings, or other tangible items that are in the control, care, and custody of the contractor. So typically, we would require this when there's a high value property amount, such as like large equipment, vehicles, or fine arts, where the contractor has care, custody, and control. And the amount of coverage required varies based on the value of the property. So we'll usually have language that requires a contractor's policy to have a minimum limit equal to the property's value. And again, because we have a property interest, we require that the contractor list the state of Michigan as a loss payee on their policy.
Can I pop in with a question?
Sure thing.
Okay. Would medical coverage apply to pre-employment testing, for example, drug tests?
I would say no, because there's not really any kind of medical diagnosis or medication, prescribing of medication involved with testing. And there's really no malpractice that's involved with pre-employment testing. There may be a need for professional liability, however, because you're not really dealing with medical professionals when the services involve pre-employment testing.
What about workman's comp claim?
So I'm not sure I understand that question. I think
Okay, Melissa, I think that was yours. If you want to, there we go. Hurt on the job. So someone that's hurt, I guess a person that's hurt on the job. Is that covered?
On the job injuries is really just specific to workers' compensation. I think if the question is pertaining to medical malpractice, yeah, no, those are two separate types of coverage. One, medical malpractice has nothing to do really with on the job injuries.
Okay. And then I do have one separate question. Does the state require insurance for entities that protest or for unions that may strike on premise? No, that's a little, might have been the slide before.
Well, specifically speaking from the perspective of contracts, no, because an entity or business that's protesting, we don't have a contractual agreement in place. So we can't really require them to provide insurance coverage. And same goes for unions who are protesting. There's really no contractual agreement where we can legally impose a contractual requirement to provide or to carry insurance or coverage. Right, so looks like we got about 9 or 10 minutes here. So to kind of go through the last part of the presentation, we've talked about some insurance requirements. Now let's take a quick look at what an accord form looks like and how a contractor provides proof of insurance. Oh, and it looks like the next slide is our next polling question.
Okay, this one I think is our last polling question, and then I will let you run through as many more slides. I know this is a lot of content, so trying to get through, and everybody's had amazing questions, but I think we'll try to get through the rest of the slides without questions, and then we can always take a summary after. The acronym ACORD, ACORD, stands for Association of Cooperative Operations Research and Development. That's a mouthful. True or false? Man, government, we have so many acronyms. It's like I remember when I first started, I had a cheat sheet that I had to reference all the time, and I probably should still reference it.
I still have that on my desktop, actually. Every now and then I have to open it up and add a couple more acronyms to it because we never.
Oh, sure. All right, so here's the results. Is that true or false?
So it's actually true. ACORD does stand for Association for Cooperation Operations Research and Development, or Cooperative Operations Research and Development. And what ACORD is, they're a global standards setting body in the insurance and financial services industries.
There you go.
And most of you are probably familiar with the term ACORD or ACORD forms, because on the next slide, you'll see this is where at the bottom of certificate of insurance, an ACORD form, you'll see the word ACORD at the bottom left-hand corner. And so, excuse me. So let's briefly review the various parts of an ACORD certificate of insurance. And what we'll do is we'll start our way at the top and then work our way down to the bottom. And I apologize if I fly through this, but it looks like I'm getting short on time here.
You are.
So the very first box or the space towards the top left is where you'll see the contractor's broker or the insurance agent listed. And then the very top of the form, right above that, is there's a statement that indicates that the insurance policy is listed on the certificate is what governs coverage, not the certificate itself. So if there's ever a conflict between what's provided on the certificate of insurance versus what's actually covered under the policy takes precedence. And it's important to note that it's actually a felony to misrepresent any information on a certificate of insurance. So it would behoove the insurance agent or the broker, the brokerage firm, to not misrepresent the information on a certificate. But if it is, the policy itself takes precedence. And then over to the top right is where the broker or the agent will list the insurance companies that are providing the coverage. And then the letters, insurers A, insurer B, insurer C, correspond to the policies that will be listed in the middle part of the certificate there. So yeah, if you click to the next slide, yep, it highlights there's where you'll see the letters A, B, or C that will correspond to the other highlighted box there on the slide. Right, and then the box right below where the broker's agent would be is where the contractor's name will appear as the insured. They're the insured party. Right below that is where ACORD does a great job at reminding us the insurance policies themselves supersede any information that's provided on the certificate. That middle portion is where you'll see the insurance policies that are listed. And it will also specify whether it's a claims made or an occurrence-based policy, whether the auto liability policy includes hired and non-owned coverage, things like that. And then those two narrow columns that are to the right of each of those policies will indicate whether or not there's a additional insured endorsement or a waiver of subrogation. They also have the option, and I'll get to this in just a second, but they also have the option of putting it down in what's called the description of operations box right below. So then you have the inception and expiration dates for each of the policies. And then even the next slide, the limits of coverage listed to the far right of each of those policies.
There's a lot on this one little form, isn't there?
All right, and there's that description of operations box I was talking about where additional comments can be made. Sometimes they'll say that additional insured endorsement applies, a waiver of subrogation applies. Kind of like a little additional comments box. That left-hand corner is where the certificate holder is named. So in our case, it'd be the state of Michigan. And then to the right of that, there is a statement that any cancellation notice will be sent to an additional insured if a policy is canceled before it actually expires.
And I know I said no more questions. Is the cert, if it's a let's see, appropriately endorsed. Does it matter if the Y is entered into the additional insured column?
It does not. It can either have the X or the Y in that narrow column indicating an additional insured or waiver of subrogation, or they can put a statement indicating the same in the description of operations box.
Okay. So I know you have a couple of reference slides. Yes, I'm getting a few questions because I know we're at the end. People are saying this is a great reference document, so wonderful. I'm glad we got to go through that. And then, yes, it is recorded, so I will make this available online. We've got some sample reference requirement scenarios. I think this would be a good review for when we send the slides out that they can kind of go through. And is it okay? Your information's on here, but if they have a few questions following this, is it okay that they reach out?
Yeah, absolutely. This is basically what I mentioned at the beginning of the presentation, where everything we've talked about kind of comes together, and we would apply it to one scenario with the contract's requirements and then the certificate of insurance that was provided to see if they're actually meeting the insurance requirements. And you'll see that there's either a red arrow or a green arrow to indicate whether or not they've met or they haven't met the insurance requirements. I should mention, though, that this presentation was created in 2018, and it, unfortunately, I apologize, hasn't been updated since. So while looking through this scenario, you're just going to have to kind of pretend that it was the beginning of 2018, because an expiration policy, a policy expiration date today would appear as if it had expired, but back when this presentation was created, it was not. So you'll see a green arrow indicating that 2018 is okay, when obviously in 2022 it would have been expired. So just keep that in mind.
Yeah, so there's a scenario that will be included in your slides when I send that out to you. And I mean, I can't thank you all enough for participating, because your actual participation with these questions have been great. And I'm sure that's helped other attendees to hear those questions. So thank you so much. Gavin, thank you. Really appreciate it. I know that was a lot, but it's been great to learn more about it. And I know our members had really wanted something like this. So thank you. I will get this recorded. Please answer your survey questions after you leave. That way we can make sure we continue to offer great programs like this. We just got such a great team at the state that, you know, could really come to the table and bring us great topics. So we'll keep working at that and getting more topics your way. So thank you all. Hope you have a wonderful fall weekend, and I will talk with you all soon. Thanks, Gavin.
Thanks, everybody.